Even though the coronavirus job retention scheme runs to 31st of October this year, many employers are having to make difficult decisions about the future of their businesses, which can include making redundancies, and now is the time to make these difficult decisions. Redundancies in employment law can be a minefield, and it may seem unfair to make employees redundant, and no one wants to have to do this. However, if difficult decisions are deferred, more drastic action may need to be taken later on. In legal terms, it is perfectly fair, provided there is a redundancy situation and a fair process is followed. As we all know though, redundancy can have a significant impact on the morale and well-being of employees. Couple that with the current economic climate, predicted large-scale unemployment and concerns about the number of new jobs, and there is no question that employees will have their own views about what is fair. It is therefore doubly important that employers approach a redundancy process fairly and lawfully, treating all employees with dignity and respect. Even aside from the legal risks of getting it wrong, which are not inconsiderable, handling redundancies in a compassionate way can make a significant difference to how people cope with the process. It will also have an impact on all the other employees who will be affected by the unsettling experience of seeing their colleagues being made redundant and who may feel their own job is at risk. Planning the process properly is therefore absolutely vital. Given that the coronavirus job retention scheme is currently due to end on the 31st of October 2020, with government funding progressively diminishing until this date, it is essential that employers make any difficult decisions as soon as possible. This will ensure that there is time to plan and, when the time comes, follow a lawful redundancy process whilst making best use of the furlough funding. Yes, provided you do so fairly. If you don't, and employees may remind you that the coronavirus job retention scheme was put in place to help organisations avoid redundancies, employees who are made redundant may bring an unfair dismissal claim. Whether a dismissal is considered unfair by the Employment Tribunal will depend on the circumstances and how reasonable the business was in making those redundancies. Employers should consider alternatives, which may, for example, include fully utilising the furlough scheme before any redundancies take effect. We can take you through what you need to do step by step, helping you get the process right. This can help make the process run much more smoothly for both employer and employees, as well as reducing the risk of an expensive legal claim.